welcome back to the second part of our rule of law event. This section of the afternoon will initially commence with a talk by Danube Institute head of foreign affairs, Dr. Akos Bensegat, who's written a book that seems to have sold out from the Institute on European policy on the rule of law. If anybody's interested in a copy, you should give me your name afterwards. Anyway, Benche is going to talk about the rule of law debate in the EU, which is an extension of some of the arguments we heard earlier this afternoon about judicial activism. And that will be followed by a panel with all the speakers, including Bense, moderated by myself. So over to you, Bense.
Thank you very much. So my name is Akos Bensegat, Head of Foreign Affairs at the Danube Institute, and I'm pleased to be here with such distinguished speakers and the audience. So thank you very much for this opportunity and being here at this conference. So I start my presentation with this picture which dates back to 2011. This was the time when Hungary had the first EU presidency ever in its history. It's important because next year we will have actually the second one, and this is a very interesting episode because that was the very beginning of the rule of law criticism. When Prime Minister Orbán presented the Hungarian EU presidency's program, he was suddenly attacked by several MEPs from the left and very often from the radical left, who were criticizing Hungarian interior politics. So they were not discussing about the Hungarian EU presidency program, but Hungarian internal issues. And that was the first phenomenon because on the right, you can see on the picture Daniel Cohn-Bendit, who is a French politician who was active back then, an MEP from the French Greens, who was practically shouting at the Prime Minister. And I remember back then I was a student, we were learning a lot about the European Union. We had an illusion that this is an institutional system which serves the cooperation between nations. And what we had to realize is that it's not that amical or friendly than it seemed to be in the textbooks, because we have very, very crude political debates which are maybe normal in national parliaments, but at a diplomatic scene when different MEPs from different countries are attacking prime ministers, I think this is a quite strange and new phenomenon. Back then this was an exception because the majority was not behaving like that. But if you take a look at the majority after the 2019 European Parliament elections, we can state that this kind of behavior kind of became the rule rather than the exception. Today, I would like to speak about what happened institutionally, at institutional level, in the name of the rule of law during the last decade, last 12 years. I will speak briefly about 6 rule of law instruments that you can read here. Here, the rule of law report, the rule of law framework from 2014 of the European Commission, the rule of law dialogue of the Council, the EP's proposal for an EU mechanism on democracy and rule of law, the annual rule of law report of the Commission, the conditionality regulation, and also, last but not least, very fundamentally, the Article 7 procedure. These are all rule of law instruments in the European Union, and these are all except for Article 7 procedure. These are all new procedures which were set up during the last decade, last 12 years. So, first of all, I would like to bring you some often forgotten evidences about contradictions between the different European rule of law instruments. These evidences are produced not by myself, but by the EU institutions itself, you will see. The first one, it's more a kind of piece of starting point of European rule of law debates, where you already have a proposal which is happening right now. This is a letter, a quote from the letter issued by German, Dutch, Finnish and Danish ministers of foreign affairs, addressed to the president of the commission, back then José Manuel Barroso, in 2013. And in this letter, these foreign ministers, these ministers of foreign affairs, suggested that the EU sets up a new and more effective mechanism to safeguard fundamental values in the member states. And they said also that as a last resort, the suspension of EU funding should be possible. You know, it was back in 2013. Let's keep this in mind because this will be important for the next episodes. In 2014, the European Commission replied by issuing a document or setting up a first rule of law tool, which was called the Rule of Law Framework, the framework officially for strengthening the rule of law inside the European Union. And in this very communication, the Commission officially put the following: there are situations of concern which fall outside the scope of EU law and therefore cannot be considered as a breach of obligations under the treaties, so under EU law. And therefore no infringement procedure is possible against these questions, but these questions for them pose still a systemic threat to the rule of law. So what is written here is that the Commission started to act in matters that fall outside of EU competencies. Here we have to stop because it's an important point, because European institutions are supposed to follow the treaties, may follow what is written in the treaties. This is the legality, this is the rule of law of the very European Union. Of course, it's not only myself who say that it is problematic, but back then, there was the Council, and especially the Council's legal service in 2014, which reacted by issuing a legal opinion on the Commission's rule of law framework. So the Council in the EU, this is the EU institution where the ministers of the different member states get together, and this Council has this legal service with lawyers. The lawyers of the Council wrote officially that the respect of the rule of law by the member states cannot be under the treaties the subject matter of an action by the institutions of the European Union. And they also followed, there is no legal basis in the treaties empowering the institutions to create a new supervision mechanism of the respect of the rule of law by the member states. So it's very clear. This is where we are legally, where we were legally back in 2014. And the Council agreed with this legal opinion as well, and that's why the Council put in place a parallel European rule of law mechanism, which is called the rule of law dialogue. So the Council put in place the so-called rule of law dialogue because it wanted to concurrence the Commission's proposal, which the Council found inadequate to settle these rule of law questions in the EU. And the rule of law dialogue, very briefly, was a kind of discussion every year about the rule of law as a broad topic and not about a specific member state. Of course, since then, the situation evolved, and nowadays the Council's rule of law dialogue is much more focusing also on member states and is discussing all the member states. But back then, that was not the Council's position. The European Parliament also criticized the Commission because it found that the Commission's rule of law framework was not broad enough. What was the Commission's rule of law framework? It was, if you breach EU law, you have the infringement procedures. That means that there is an exchange of letters between the member states and the Commission about a legal issue, and if they do not find a solution, at the last instance, they can go to the Court of Justice. For these questions of rule of law outside of EU competencies, the Commission put in place something which was quite similar, a structured dialogue an exchange of letters, a political pressure mechanism, but without the possibility of going to the court. For the parliament, it was not enough, and the parliament suggested the introduction of an annual rule of law report. But the parliament has no such power inside the European institutional system to initiate on its own a new mechanism, a new rule of law mechanism, so that the parliament relied on the Commission and requested from the European Commission that the European Commission comes up with the idea of an annual rule of law reporting mechanism. So that's why the Commission had to react. And the Commission reacted by saying that it had serious doubts about the need and the feasibility of an annual report of the rule of law, and emphasized that a range of existing tools and actors already provide a set of complementary and effective means to promote and uphold common values. So the Commission will continue to use these tools rather than setting up new tools such as the rule of law mechanism. But don't forget this, because 2 years later, the Commission came out with the idea of introducing a rule of law report, annual rule of law report. It was in 2019, during the EP parliamentary elections campaign, that Franz Timmermans, back then first vice president of the European Commission, proposed to set up an annual rule of law report in 2019. And after the elections, it was done, and the first report was issued in 2020. And then every year there is a annual rule of law report issued, published by the Commission. So there is a contradiction here, because in 2 years the Commission completely changed its position about this question. So it's going against itself as well in this matter. So what is the annual rule of law report? The annual rule of law report is an examination of each member state each year on the ground of 4 topics related to the rule of law: level of corruption, media pluralism, judiciary system, and other institutional issues related to the checks and balances. That is what we have, the annual rule of law report. This is also a political pressure mechanism. But then we have also another interesting instrument introduced proposed already in 2018 and finally introduced in 2020. This is the so-called conditionality regulation. The conditionality regulation is the means which is used now by the Commission to cut the EU fundings from Hungary. How it functions. They say, we think that this member state doesn't respect enough the rule of law. This can cause a concern for the European Union's budget, so that we can, freeze some EU funds of the country. This is a very hard question, because remember that at the beginning I said that even according to the legal service of the Council, a nice political pressure, the rule of law framework from 2014 was already illegal for the Council. And now we arrived at the point that we are speaking about money and we are cutting EU funds from a country. Is the European Union supposed to do so? Is it legal? There was a very interesting legal debate on this issue, and very briefly, you have to understand the 2 different logics which are confused totally in this conditionality regulation. The first one is that according to the EU's legal system, according to the treaties, the Commission cannot, or the European Union cannot introduce a procedure to sanction a European member state financially because of alleged rule of law shortcomings. And this is quite clear. So that's why they said that they are not introducing a complementary rule of law tool which is allowing for financial sanction against a member state, but they said they are introducing a tool in the name of the protection of the EU's budget, because there they have the legal fundings, they have the legal basis. And when they went to the court, because Hungary and Poland attacked this regulation, at the court they argued, sorry, this is not about the rule of law, this is not a sanctioning mechanism, this is about protecting the EU's budget. And the court validated this. At the same time, parallelly, meanwhile, the procedure was ongoing before the court. In the media, in the European Parliament, both they argued, we have finally a tool to sanction the rule of law shortcomings in the states, in the member states. And this double logic is not only my finding. I wrote this in my book before this text came out, but this confirmed what I said, that there is this two parallel logic confused in this question, because the Advocate General of the Court of Justice, which is supposed to prepare a pre-decision for the judges of the European Court of Justice, confirmed that there is this two possible way of interpretation of the constitutionality regulation. And he also confirmed that if it is not a budget protection tool, but an instrument to protect then it would be another instrument to protect the rule of law with budgetary implications, for which Article 322 would not offer an appropriate legal basis, and the European Union would not have the competence to introduce. Which is interesting. What is interesting is that in the final judgment, this has completely disappeared. So the judges of the European Court of Justice directly went for option A without discussing the second possibility. But this is the core topic of the debate legally, and this raises questions. So finally, I would like to come back to the Article 7 procedure before my conclusion, because the Article 7 procedure is the only one which is really in the treaties. The Article 7 sets up two procedures. The first paragraph sets up a procedure which lets the member states to establish that there is a serious risk of breach of the rule of law in a member state. And the second paragraph allows for establishing that there was already an actual breach in the member state. And only the second paragraph can lead to sanctions, and these sanctions can be withdrawing the rights of vote in the Council of the Member States. And we could also understand in this that maybe some financial sanctions are possible. But for the second paragraph, the unanimity of the Member States is needed. So and it's very difficult to achieve, especially when Hungary and Poland can help each other in this question. And that is why all the previous procedures were introduced in order to circumvent the Article 7 procedure. So here, ladies and gentlemen, we are in face of a very, very serious legal problem, and this is a legal problem which touches upon the EU's rule of law itself. So now, in order to be in a frame, I come back to this first picture I used to introduce my topic, and I asked the question whether next year, in June 2024, we will have the same kinds of debates, maybe with other MEP, of course, because he is not anymore in the European Parliament. Will this continue? I would like to argue that in 2011, no one was prepared that Hungarian presidency will be attacked. Now everyone is prepared because the attacks have already started on the Hungarian presidency. But we will have European elections next year, just before the Hungarian presidency. And we never know what God's want. Maybe this will be a turning point. Now we are prepared, and then we will have to face with a room of nice MEPs towards the Hungarian Prime Minister. Thank you very much.
Thank you, Benji. So now we're going to have a discussion with the panelists and me moderating. So I'd invite Bence, Jim, Gaudi, and Professor Varga to come up and take a seat. And then I'll kick off some discussion and we'll have some questions and answers from the audience. So that was a fascinating discussion of the manner in which the rule of law has become not the protection of individual liberty, but a mode to seemingly crush it. This didn't seem to be the case. Well, I mean, Jim, you gave the example of Kennedy in the 60s, but and what he was standing for would now seem extremely right-wing. When did this movement come about to sort of weaponize law? It seems to be, without sort of becoming too dogmatic about it, a quasi-Marxist project. I wondered what all of you thought. You've all got a microphone, by the way.
It works. I would put it down to the way the law schools in the English-speaking world have sort of been. I mean, there's almost no conservative legal academics left. There's a few, but not many. And so they just naturally, if you're spending 3 years being taught by, it covers the whole spectrum of opinions from A to B, with A being hard left and B being sort of center left. And so it's not surprising that where I would say 50 years ago, if you in Canada or Britain, you took the median voter, the median lawyer's political views would be more conservative. I mean, that's what we all grew up with. And so judges all gone to Oxford and Cambridge, that sort of thing. Today, if you took the median voter in any English-speaking world country, the median lawyer would be to the left. And not the old-fashioned sort of redistribution of wealth left-wing parties, the sort of Dennis Healy, the sort of kind of left-wing parties I sort of have something in common with. It would be the sort of human rights barrister left-wing parties. And they would represent the law societies think that way, the barristers associations. And so given that these are the kind of lawyers you're producing, judges in the English-speaking world are chosen from the lawyers, it's not really that surprising. And they have a certain disdain for people who don't share their worldview.
Well, that came across in all your talks. I wondered what about, Gary?
I agree, but I think that we have to understand this in the context of the reaction of elites against nationalism. Elites have developed a frame of mind in which nationalism is the culprit of everything. This is their interpretation of World War II, and then it dominates everything else. And elites have been terrified by the rise of nationalism. For me, I saw it in Israel, and then I started reading about it in other places and seeing it was the same. It was very personal for me. I was 12 when Begin, the leader of the right, took power in Israel after 4 decades of labor rule. I had a field trip that day, and I was 12, and I came down from my room, and my mother said Begin was elected, and I sat down on the floor and cried, because to my young mind, what I understood from the adults around me, this was the end of the world. And then I saw what happened, because my parents belonged to that elite, and it was called the 77 Circle, because it was 1977. And though my parents remained Democrats, their friends drifted off into what they wanted. The puzzle they needed to solve is how do you limit the power of these wild masses of nationalists? And so the key was mostly jurists and mostly courts, because that is the fundamentally elitist branch of government, the professional, the educated branch of government. And so they realized that their weapon would be rule of law, and by the way, human rights. Human rights are
Can we come on to that? Because I think,
sure.
But I wondered what Csaba and Bencsé thought.
I shall look like a cynical, albeit I am not. But I'm a legal philosopher for I'm a professional researcher for almost 60 years, so having lots of experience. And I would reply with the terms of the deeply rotten, morally genius of Hungary, George Lukács, the philosopher. In his posthumous ontology, he had two wonderful terms. One, Vergesellschaftlichung, the other one, Vermittlung. The first, for socialization, namely that the social contacts have become indirect and no direct social contact has remained in the more complex and so on present day world. The other term, Vermittlung, is the, let's say, intermediation. So all our relations have lost their direct nature. So I would say that this debate is the whole role of law and our human and humane institutions are just a Vermittlung, a mediation category. They do not matter. What does matter is power relations and power game. So they have no independent force. Yeah. They are just parts of a game. And what's on? We have a pair of concepts: rational, irrational, theist, atheist, conservative, liberal. Each of them have a kind of psychology. So there is a more active part and there is a less active part. So I guess that we are really in a world fight.
Well, I think the reference to Lukács is very interesting, because listening to Professor Stump's talk as well, and this sort of distinction between legality and legitimacy, it was very interesting how the Frankfurt School particularly got interested in, well, human rights, but law as a mechanism. And it was interesting, Bence, in your talk, you mentioned Cohn-Bendit, who's got a long trajectory in this. So the European dimension has maybe got a more, Frankfurt School element to it. I wonder what you thought.
So, yeah, thank you for coming back for Cohn-Bendit. Just for a word, for me it's very symbolic, because he was already active in attacking General de Gaulle in France and the 68 movement. And the fact that he attacked that violently Mr. Orban, for me, makes a symbolic link between the two big statesmen, which is Mr. Orban and the French statesman General de Gaulle, and they have a lot in common, even if different countries, different contexts. But there is some Gaullist thinking in the mind of Viktor Orban as well. It is very interesting. Now, so as for the rule of law, I think that there is a kind of totalitarian approach to the rule of law, and Professor András Vargazsi published also a book on this. He's currently the president of Korea, the Supreme Court, but which already in the title puts that basically the rule of law became from an ideal an idol. And in the name of the rule of law, we can make coup d'etat. So now it starts to make sense, because we all agree that there are common points in our presentations, and that there is this coup d'etat part, there is this how to take the power from democratically elected bodies, from democracy, and how to organize or outsource them to other levels where the decision making is not democratic. And I think that we should form a kind of school, because the school of the rule of law, and especially when it comes to criticizing Hungary and Poland, is quite a rigid one. So there is a school of EU rule of law, but I think that now we are enough to form a counter school, because we come to the same observations.
Well, that's very good. So you mentioned, Gaudi, well, I kind of cut you off on human rights, but one of the sort of features of this evolution has been how international law, human rights regimes trump domestic law or domestic considerations. How has that evolved? Human right. When I used to be doing political thought in the 70s or 80s, rights talk was interesting, but rather a parochial concern. human rights, didn't used to be an interest of the left. They took off from the 80s, I think. How is it it's become so powerful, given that it's actually foundationless, it seems to me?
The Israeli experience, I think, was very illuminating here, because we had the misfortune to notice how human rights became an anti-national weapon, because they became, in Israel we now say every organization with human rights in its title is probably anti-Semitic. It's almost universally so. So how did this turn around from human rights being something Jews upheld in order to protect their rights as a minority, and became a tool of attack to delegitimize the Jewish state? And I think here Israel and Hungary are at the same front, because both, and this goes back to my first point, both are trying to protect the right of self-determination, right of national self-determination, and both are, I think, the paradigmatic now nation states protecting themselves from a globalist and international bodies that are trying to siphon their sovereignty, and this is how the anti-national aspect of human rights became anti-democratic too, because the national publics, democratic publics are mostly national and want to preserve their national identity. So the only way to transcend nationalism is by transcending democracy. And the way to do it to the liberal mind is speak in the name of a universal regime of human rights. And I think the person who laid out the map for this is John Fonte, probably the most underestimated thinker of this generation.
Thank you. Very good. Jim, do you want to comment?
Gaddy's too polite to say, but I think off the top of my head that there have been more UN human rights resolutions and General Assembly and UNHRC resolutions against Israel for rights infringements than for every other country combined. That shows you how ridiculous it is. So the worst place to be a woman, apparently, is Israel. Now, if that's not making you laugh out loud and think that there's a real problem, from the English-speaking sort of tradition, you can go back to the late 1700s, and Jeremy Bentham was pointing out the problem with rights. The problem with rights is you sell them in absolute terms, so that when you say, you have the right to free speech, everyone imagines that it's his or her conception that will play out, right? A sort of absolutist thing. But in fact, what has to happen is that someone has to make these determinations. And so you can't actually sell them in absolute terms. So people support it until you hand it over to somebody, which is the judiciary. And I don't think you can really get much better still than the Bentham critique of the French Declaration of Rights. It still pretty much lines up with our views. But I agree with Professor Taub that this movement towards having some sort of entrenched rights-related document in your constitution, and people need to remember that if you go back to the 1950s, there are only two countries in the world with a Bill of Rights, the US and France. And, the French one's older, but it wasn't even justiciable until, 10 years ago. So it's really an American thing. And the Americans have learned over time how to deal with a very powerful judiciary, right? The rest of the world has not yet learned how to deal with it. How you appoint the judges is a party political term. In the Westminster world, we call what the judges do judgments. The Americans call them opinions, because they are opinions. And, you have a politicized appointment procedure. And if you're going to have these really powerful judges, I don't like it. But if you're going to have it, you need to go down the American road. And that's what Israel needs to do. Because right now, they're trading off 300 years of being, and I'm talking about in sort of the British tradition, they're trading off 300 years of being impartial law appliers. And then in the last 20 years, they've been given this incredible power that travels under the aegis of interpreting rights. And they're not impartial, and they're not apolitical anymore.
Right. So in Europe, under European guidance, it seems to have evolved somewhat differently. Do you think, Professor Varga, or?
Well, I would answer rather in general terms. What I see here most intriguing is a kind of a sharp counter point for demos on the one hand and juristocracy on the other one. We prize that because of professional skill and so on, like the old British judges. And this one just by chance. But at the same time, democracy is being based, or has been based for thousands of years. And now, in Hungary, for instance, Béla Pokkal, a constitutional justice now and professor of legal theory, he is the monographer of the juristocracy, just claiming that practically from the power of the parliament, nothing has been left because everything is being interpreted. And you may remember from old Kelsen coming to United States of America after the Second World War in '46, publishing his Poe's Theory of Law in English in another one. And from Gray, an American legal philosopher, he quotes a fantastic 17th century British prayer, just claiming that God is there, but we are to interpret, we priests and so on, and who has the last word to interpret him is the genuine law giver. So juristocracy means just that. Right. And we have no arms. And again, use of law can be aggressive and non-aggressive. We see a partner here in that part of Bence's picture, an aggressive use of law. And the point, again, Kelsen was a Jewish liberal and so on, a fantastic one. Continental legal thinking cannot survive without Kelsen. So this is Max Weber for us, let's say. And the Kelsen concluded, again, after the Second World War, who is the guardian of law? Not the constitutional justice. The guardian of law, there is no one. So after all, the people or no one.
Very good.
So law is just an instrument. Whose? The stronger.
And the instrument is being wielded very heavily by the European Parliament.
Yes. And
what was quite interesting was the way you described this sort of kind of dialectic between the Commission and the Parliament, who just seem to egg each other on to take another step against a treaty regime.
Yeah, it's a bit more complicated even than this, because they are also in concurrence. So political concurrence, the Commission, institutional concurrence, the Commission, the Parliament, and the Council as well. I have the feeling that we can say that the Council is attacked by everyone, because these are the member states, and the Council has its legitimacy from the national sovereignty. So that's why the Council is the most attacked institution. So the European Parliament every time criticizes the Council, of course. And in the development of this rule of law tools, we saw this institutional concurrence as well. And it was also a power struggle. That's a good thing to have the rule of law because we can have more power, but who should have the right to interpret the rule of law? Who should have the right to examine the situation of the rule of law in the member states? The big difference between the annual rule of law report suggested by the European Parliament, which never entered into force, and the actual rule of law report of the European Commission is that in the Parliament's rule of law report, the Parliament would have played a much major role. than the European Commission. And in the European Commission's annual rule of law report, the Commission plays the major role, and there's no role at all for the European Parliament. So there is this power struggle. And coming back to this question of the aristocracy and democracy, and also Professor Varga mentioned that there's a kind of source of legitimacy coming from the professionalism of lawyers or of the elites, which is de facto a kind of political legitimacy, which is a way. Political legitimacy can come from God, monarchy, from family, from democracy, from technocracy, from aristocracy. But now what I realized, for example, when I was subject to I participated in some procedures regarding the conference on the future of Europe, or regarding the country visit of the European Commission preparing this year's annual rule of law report. I was very surprised that even the quality of the legal reasoning is missing. To tell the truth, there were no legal reasoning at all. It was like, we raise a concern, we give an argument, a legal argument, and they say, sorry, it is our methodology. but the way you apply, and please give some reasoning. Sorry, it is our methodology. So it is kind of very autocratic approach, because it doesn't take even the effort to prepare a nice legal reasoning, which may be true or not true, or convincing or not convincing, but the hard jurists of this big bureaucracy will kill this small jurist who made the national schools, and no, there is no such things. So the game is not happening at the level of arguments and this who is smarter, but the game is very much happening on the power relations, who is stronger. And the European institutions think that themselves are stronger than national institutions, and that's all. So it comes back to very crude international politics at the end, which is a problem, because I think that the European Union was set up in order to organize a peaceful cooperation between the member states, in order to organize the compromise. And during the last few years, this tradition is has been disappearing from the European Union, and this is a problem for the peaceful cooperation of the member states as well.
Yeah, okay. Well, that's very good. I think we could open up to questions from the audience now, if anybody wants to raise their hand and ask a question. John.
Thank you, John O'Sullivan. I'm in agreement with virtually with all of the speakers on this problem of the elite's grip on the structure of the system, so that my question really would be, it's really addressed to everybody, but on one part to Professor Saud, and that is this. He's arguing really that the elite's hostility to nationalism is the fundamental point. I would say that's epiphenomenal. It's hostility to democracy, which is the fundamental point, it seems to me. And I notice that this hostility is emerging on more and more issues in more and more places. I'll give you a couple of examples. One is the Financial Times the other day advocated new forms of democratic arrangements, which include, for instance, what they call citizens' assemblies. Now, citizens' assemblies, as it was clear from its argument was, it said, look, the electorate made a mistake on Brexit. It makes mistakes. That's because it doesn't know anything, and it needs to be tutored by experts. So citizens' assemblies in which a group of representative ordinary citizens meet experts and spend several weekends discussing a topic with them will vote on these questions. And they generally reach better conclusions once they've been sequestered with a lot of propagandists for about a month, okay, or over several weekends. And they are seriously suggesting that this is an improvement on democracy, and by the way, they're making ground. The British Parliament actually established a citizen assembly on environmental policy. and they went away and they came back with all the things that the Green parties wanted. And my argument is this kind of critical attitude to democracy and a willingness to look for oligarchic additions to it that bias it, it seems to me to be easier to sell in countries which have really had democracy for a long time. It's my impression that it's in Central Europe and Eastern Europe that the oligarchs have a harder time in trying to persuade the whole system, but particularly the voters, and governments to surrender their democratic forms of decision-making and hand them over to courts. I think that was clear from all three of the Hungarian speakers today. I mean, for them, the perpetuation of democratic majority decisions was a very important element in governing, and not simply a secondary item in rule of law questions. I wonder if...
Yeah, thank you, John. Professor Varga, probably first.
Well, it's hard to me to answer directly. What I do have in mind is that the bad feeling, as if we were to live in a kind of a continued dream, trusting upon words, trusting on human speech, trusting on human mutual understanding. And if I do remember, in England, perhaps in the 17th century, but especially with Jeremy Bentham and many others in the 90s, on the field of law especially, against the fiction and so on, there has been an expressed fight against the bad use of language, for a kind of a plain language, for that language shall be purified and so on. So I guess that we are living in a dream that the words are what they used to, albeit they are not. And again, what I see is that everything has been instrumentalized for this kind of power game. Sorry.
Thank you. Benche, do you want to?
Yeah, thank you. So as for this idea of organizing new democratic forms, I think that we can come back to this idea of there is the rule of law. So in the name of the rule of law, we try to replace democracy or to override democratic decisions. But still there is this disturbing phenomenon that we all pointed out, that we should do something with democracy, because if the democratic decision is not in line with what the rule of law camp suggests, this is still a bit disturbing. So let's correct the democracy by a democratic way. So that means that if the representative democracy doesn't produce those outcomes that they want, they try to outsource representative democracy and transform it in another way of democracy. I think that the idea of getting citizens together and discuss and debate, it's a wonderful idea, of course, but maybe it's more an ideal, and I don't know if it can be perfectly done. In a small city or in an ancient Greek city, maybe it was possible, but for states and countries, I think it's much more difficult. And there is one concrete example. I already mentioned the conference on the future of Europe. And the conference, in the framework of the conference on the future of Europe, at European level, they organized several citizen assemblies. They took 200 or 400, I think 200 citizens in a panel, maybe 4. I have a former colleague who knows the exact number here in the audience. But basically, they chose to discuss the topic, but there was a point where all the procedure was a bit tricked. That at the beginning, during the first weekend, there was a presentation by experts, also on the rule of law, and it is enough to check the name of the experts who intervened in the citizen panel treating the rule of law issue of the EU is that all left-wing thinkers who regularly criticize Hungary and Poland, so they are all in one camp. It's a legitimate position, but where is the other camp? Because if we choose citizens randomly, and of course maybe they have no idea of such political or intellectual questions because it's not their everyday job, so it's absolutely legitimate, then they listen to someone who influences them, and then the outcome is already written at the very beginning. So I think that at Citizens' Assembly, we have to make sure that the counterpoints are presented equally to the citizens, but I really believe in representative democracy.
Okay, so at the risk of my free dinner tonight, I'm going to try to disagree with John. I'm not sure I've ever done this before. So I think Brexit basically broke the Tory party in Britain, and Britain's a bit of an outlier because about 2/3 of Tory MPs were Remainers and 3/4 of the party base were Leavers, and so they've never really been able to properly implement it, and they probably agree, half of them agree with the Financial Times. But if you look at the US, they seem to me to have a system that's more, I mean, there's many problems with the US right now, but a desire not to be a nation state doesn't seem to me to be one of them. They have democracy right down to the level of school boards. You know, they don't have 50 school curricula. They have, in some states, the county set the school curricula. And during lockdowns, parents were going and complaining to school boards because the schools weren't open. The kids had to wear masks. You know, the FBI were labeling them terrorists. But there wasn't this sense that the democratic sort of process was, you know, it's the big ticket questions in the U.S. at the national level that democracy seems to be on the procedural level in question. And so even that sort of appeals to international law don't work in the U.S. because you can't enter into a treaty in the U.S. unless 2/3 of the Senate agrees to it, which means they almost never enter into a treaty. So Clinton can't bring in the Kyoto Treaty, and Biden can't bring in net zero. So they do it in some sort of fake treaty way, and so that's easy to get rid of. And so I think Americans basically, if you said to them, is there something better than the nation state? Most of them would laugh at you, even most Democrats. So I'm not sure it applies to the U.S. Canada just elected at the provincial level in Alberta last week a government that would be one that John and I would, very much like. And so there seems to be more resilience outside of Britain. Britain seems, and I think it's largely because the Conservative Party in Britain seems to be broken. So it needs to be broken faster and more, and something else needs to grow up. But I agree with his prognosis. I just don't know that. I think Britain's the worst of the lot. Australia is trying to bring in right now a democracy enervating constitutional amendment. And luckily for Australia, we 120 years ago copied the American constitutional model more than any other country on earth. But they opted not to have a Bill of Rights, and they opted to have a different constitutional amendment process. So almost uniquely, they copied the Swiss. So in order to change the Australian Constitution, this is a radical concept, you actually have to ask the voters. And, if the elites were being asked, the Australian Constitution would have been changed 20 times. The elites in Australia hate the Australian Constitution. And so, we've had 44 attempts to change our Constitution, and only 8 have succeeded. And this one is very much like the Brexit one. It's got all of the corporate money, all of the churches, all of the charities. They're all throwing their lot on one side. The government, the left-wing government, is pouring money on TV. And it started at 70% in the polls, and now it's below 50. Because at the end of the day, and this is what I would recommend for Israel, I would say to Netanyahu, just have a highly publicized referendum that you want to bring in these reforms, because it's really, really hard for the elites to say 58% people voted they want this, but we're not going to do it. That's very hard to do. So I agree with you on Britain. I just don't think it's as bad outside of Britain.
That's very good. Gowdy first, and then.
I agree, John. But I think the issues are meshed, and so the elites the elites are naturally suspicious towards the wild citizens because they are proto-fascist, as we know. So in their minds, it's the same. But the thing is that they can attack nationalism explicitly, but not democracy. So if you, when I marked Bence's book, I saw that every time the European Union had complaints about Hungary and Poland, it mentioned rule of law, democracy, and human rights. It has this clause of general European values, but they never mean democracy. They can get you on human rights and rule of law, but they mention democracy and they don't mean it because their project is to undermine democracy. And this is tied to the rule of law because national courts are their agents inside the nation states. And so they back them. And so the courts, in their fight with the other branches of government, the whole balance is upset because there used to be a co-dependent, sharing authority between three branches. Now one branch is supported by this big monster, and in its natural grab of power, it has a great advantage. And the advantage lies in citing the rule of law and citing human rights, but not democracy. So they only say it, and democracy has become I certainly agree that democracy is what they really hate. And last thing about that is that in Israel, these elites are still extremely arrogant, but they have been wrong about everything. They've been wrong about economy. They've been wrong about the peace process. And the right, less educated, more instinctive or what have you, was right. And so this is why I was on the left. I used to go to Peace Now demonstrations. And then at the end you say, wait a minute, but we're wrong. They've been right, all these, and now I go to the right-wing demonstrations. And in Israel, you can tell the difference very easily because when you go to a left-wing demonstration, you come home with your own aftershave. When you go to a right-wing demonstration, you come back of smelling 30 perfumes. People hug you, I like it better.
I'm just going to reply to that. Can I just say one word about? You can see that Gadi's right in this sense. Look what's happened in the U.S. I started law school in 1982, and from day one, I had all the people who like judges making calls. All the Americans would say, it's not power. The judges are finding right answers, and they were committed to strong judicial review. And then the incredible happened, and after trying for 50 years, the Republicans learned how to appoint judges. And so something that no one thought would ever happen in our lifetime, Roe v. Wade goes down in Dobbs, and all the judges say is it's got to be decided by the Democratic elite. And the American left-wing elitists go crazy. They now want to stack the court. They now want to undermine the U.S. Supreme Court. So it just shows it's just a tool for them. And if you learn, if by chance, and so far only the Americans said, maybe we're going to see a case come down on Harvard and affirmative action, and the Chevron doctrine is going to go. And, whatever you think of Donald Trump, he did what no one ever did. He got a U.S. Supreme Court where you appointed people who actually did what they said they were going to do. And conservatives around the non-American world seem incapable of, in my native Australia, the worst judges are the ones appointed by the Conservative Party. The left-wing judges are less activists. And they try to appoint good judges, but they can't. And, it's just astounding. Now, partly it's because, there's a little bit of sort of group-based thinking, and they want to put women on the court. And I don't want to be offensive here, but it's exceptionally difficult to find conservative women to put on courts. And so as soon as you say, well, we need a woman, they inevitably appoint someone who's incredibly left-wing. Now, there are conservative women, but they don't look very hard for, there are just not very many of them. So I would say that Gadi's right. But if you can somehow, find a way to, remake the judiciary, then these elites will immediately jettison it in 2 seconds.
Well, just a small observation to add. Namely, as far as rule of law is concerned, there are authors who emphasize enormously, heavily, that rule of law is to be kept aside. It is not human rights, it is not democracy, it is not liberalism. And especially that if rule of law is mixed or matched up with everything else, certainly there will be a chaos as it is. But especially, perhaps it was a Dutch author who mentioned that if democracy as a revendication is included by rule of law, then there is a danger that rule of law becomes a mask or a camouflage for upholding or strengthening a certain type of rule. Namely, that democracy is about what, rule of law is about how to proceed on. And when you are meaning democracy but speaking about rule of law, then tacitly you do strengthen the entity who is ruling, in fact. Because you fade, you keep silence about who is ruling, you are meaning only the rule of law ways of how to proceed on.
Thank you. I've got a question here.
Hello, my name is Sándor Kerekes. An argument, just a short one, before I ask my question. As far as Roe v. Wade is concerned, the three right-wing judges at their hearings, confirmation hearings, unanimously stated that Roe v. Wade was an established precedent and they would never think of changing it. Not to mention that the Supreme Court hardly ever changes any earlier decision. Even their most egregious decisions are still standing, especially from the slavery era, because it is their policy that they don't change their earlier decisions. In this case, I think you are wrong, if you pardon me. Okay, so much about that. Don't you think it is ironic to hold a conference in a country of no constitution and no statehood, and no constitutional court, and no separation of the powers, and no institutions to implement the rule of law, and no checks and balances? To have a conference in a country like that, Hungary, it is ironic, at least, to say the least. And just to give you an explanation, our allies, friends, and neighbors are up in arms about the deplorable state of democracy in our country, and we are fighting close quarter combat against them. Our justice minister is not too ashamed to state publicly that she, the most expected to know, actually doesn't know the definition of rule of law. And what is more, she is not disposed to read.
So what's the question, Sandor?
I already asked you the question. Isn't it ironic?
Okay, well, shall we pass that to the audience? Well, thank you for that.
I just want to first say I think you're wrong about the U.S. There's nothing from the Civil War that's still in the American Constitution, from the slave era that has remotely related to slaves. Are there some precedents that go back before 1860? Yes, but they had nothing to do with slavery. In terms of how the judges are nominated and confirmed, ever since Bork, which was when the Democrats blocked a fully capable and qualified candidate, they all use a very similar form of words. When they're asked about any precedent, they say something along the lines, I can't see anything that would lead me to take a different view right now. In other words, they all do it. The Democrats do it and the Republicans do it. In terms of you saying that no sort of precedents are overturned, it's just wrong. It's true that Roe v. Wade, no one thought it would be overturned. But that's let me put it this way. As a judge, the question is, do you owe your fealty to the written Constitution, or do you owe your fealty to past judges who have interpreted that Constitution? There's no coherent way to make an argument that you owe your fealty to the former judges who have interpreted it. Even in a common law system where the judges decisions in the past have a lot of weight. Your ultimate loyalty when you're interpreting a written constitution is to the honest meaning of the Constitution. And so if past judges have gotten it wrong, your obligation is to get it right. And I think that that is a stronger view than to say, well, because this precedent got it wrong, but it's been in existence for 30 years, we can't overturn it. That's a pretty incoherent view. Leave aside the instance where if there's an example in the US where there's an argument that actually the federal government has no sort of say over paper money, just coins. And if that would lead to catastrophic events, then you could say, okay, they got it wrong, but we've got to follow it. But no one was arguing that with Roe v. Wade or with many of the other ones. So I just don't think you're right on the US.
Benche, do you want to?
Thank you. So to answer the question, I don't think that is ironic. So that was not the goal, and I don't think it is. I think it is important to speak about this rule of law phenomenon and what happens in the name of the rule of law in the European Union and internationally. So I think that it was an honest choice, and I can see that you don't agree or you do not think in the same way. That's absolutely legitimate in this country. So it's good to have debates. And thank you for coming and listening to our opinion as well.
Okay, and any additional questions? Lady in the front here.
I'm Clara Papp from the US. Please indulge me with what may appear to be a naive question. You talk about human rights as a crucible under which numerous unjust decisions are justified in the European Union. I would like to ask about the Minority Pact, where they collected thousands of signatures to protect the rights of indigenous people throughout the European Union, and that was totally ignored. How can it be, if the European Union is so concerned with human rights, that they ignored all those signatures and that push to look at that issue more carefully? Thank you.
Professor Vollen?
Again, after many decades, I would have a cynical answer. Namely, again, in a Catholic school, I am teaching that the last judgment is not a theological teaching. It is a social science teaching as well. In our earthly world, there is no justice. In our earthly world, everything can and may happen, and everything does happen. So words are just captive. Words are just having service roles, have no independence. So you are really right that what's about European values if minority rights is not within them? It is not, accordingly, and they can argue for. Cynical, but it is. Thank you.
Unfortunately, the protection of minorities, national minorities, doesn't seem to be a priority for the European Union, or at least for the European Commission. That is what is reflected by this Minority Safe Pack and other minority protecting citizens initiative, the way they dealt with. So, of course, this is disappointing for us Hungarians who are on the side of the protection of national minorities. But this is also a kind of deception for the whole system, because when they put in place the instrument, they created this possibility of national citizens, European citizens initiative. It was meant to be helpful for European democracy, and when we look at the list of there is only a few European citizens initiatives, but there is only much fewer which succeeded. So this is an instrument that does not function, and that should be corrected. And this did not manage to fulfill the goal to add a doses of direct democracy to the European Union.
Did you want to add anything, James? Okay. Further questions from the audience? Oh, okay. Thanks.
Just on the topic of these citizens' assemblies that Mr. Sullivan talked about, isn't the U.S. founded on a similar system? Wasn't the electoral college's original purpose to sort of stop mob rule? Isn't the electoral college that is still in place today something similar to that what Mr. O'Sullivan described earlier with these citizens' assemblies?
I think Madison was definitely, and James Madison basically wrote the American Constitution. Genius, terrible president. I say that as a Canadian because, of course, he led the War of 1812 against sort of Canada. He lost because it was a tie. So we learn about the War of 1812. Americans don't learn about it. But yeah, the Madisonian Constitution is definitely designed to hamper what you might think of as direct democracy or British parliamentary sovereignty type democracy. But it's basically doing that via federalism. So the main tools he used were federalism and bicameralism. So, you know, they say the American model is separation of powers, but I don't think that's really right. Chief Justice sits on impeachment. Vice President has a casting vote in the Senate. There's a lot of non-separation of powers. But it is a check and balance regime. So the way he did it was checking and balances. The states check the center, the upper house and the lower house check each other. The judges are checked by how they're appointed. And the Electoral College is a sort of federalism-based check. So they don't have the French model. The French model is everyone just votes, right? So you have to win not just the overall number of votes, but again, it's votes, right? It's not a EU-like thing, it's votes. And on top of that, you have to win an overall number of votes in a lot of states. And so given that both parties basically use a winner takes all in each state, there's a few exceptions, Nebraska and stuff, it turns out that you have to spend some time as a candidate campaigning in the Midwest or in Iowa. And if you had the French model, you would not be doing that. Now you can say, okay, the Madisonian model undermines a blunt sort of French-style majoritarianism, and it does. But it does it by dealing with majorities in sort of assigned geographical areas. And I don't think that's the same thing. I don't think it's an elitism. It's a, how can we get this 330 million people to live together when Californians and Texans aren't even in the same planet and how they think about the world? And the way you can do that is you can do it with a commitment to federalism and a commitment to having to win through the Electoral College, say. So I agree with you partly that Madison didn't want to go down the British parliamentaries, but it's nothing like a sort of EU or a sort of Israeli type giving up on voting. I mean, in some ways, the Americans have the most democratic system. You vote for the local sheriff. You vote for the school board. There's almost nobody you don't vote for in the U.S. Now, it's true that judges are completely out of control in the U.S., but they've sort of hampered that with how you appoint them. So the U.S. is an odd combination, but it hasn't sold out on, you know, valuing the votes of your fellow citizen, I don't think.
Thank you. Okay.
Just a remark about the U.S. I think Americans and those who study them tend to underestimate American nationalism and pretend that there is no common identity. You know, John Adams used to laugh at Thomas Jefferson for insisting he's such a Virginian because and insisting on the great differences between Massachusetts, I don't even know how to say that, and Virginians. And when he goes to France, suddenly he realizes they're all American. And any democratic system can only function if there is a sense of we and a sense of solidarity. Now, in an immigrant society, it is often projected on the future, on a common future, not on a common past. But without that sense of we, democracy falls apart. And this is why I think, to go back to John's point, the attack on nationalism and the attack on democracy can never be separated. They're one and the same. And America is now in danger, as it was in the Civil War, where people consider their identities as separate. They hate each other now on the basis of identity rather than just political opinions, and this is, and we also see this in Israel.
Thank you. I think we've got time for one more question. There's somebody up here.
I'm going to be brief, and I am also not in accord with what has transpired, but I respect your opinion. One thing for G. Mellon is that the purely procedural part of rule of law, and that also goes for democracy, fails in a number of ways. I might just remind you that there was a person elected by an electorate in 1933. It was Adolf Hitler, and I guess that there's more to it. More substantive exercise of power post-elections. That's my first point. The second is about the EU and the ECG decision, and I guess it's the Supreme Court of the EU. So you somehow have to make peace with the decision that was rendered yesterday. I might just add that they ruled on a Polish law whereby the Poles wanted to impose a disciplinary commission over the Supreme Court, and they had power to propose or fire Supreme Court justices. Now, as I read yesterday's decision, and I agree I have not fully read that, one interesting thing is the EU ECG said that there's also not a national identity, but there's also an EU identity. And our EU identity is that we would not let that kind of usurpation of power and discretion prevail in the European Union.
Thank you. Okay. Ben Shea, then Jim.
Yes, if I may. That's very interesting that when the ECG, and I didn't really speak about the ECG, I didn't have time in my presentation, but when it came to the rule of law game, rule of law power game, first the ECJ took some distance from this rule of law debate because it was too much political. But then when it came into the game, it was exactly about the Polish judiciary system. But for me, that is a sign that there is a kind of coordination or coalition between judges at national and international level, maybe an elite of judges, because the ECJ jumped into the rule of law debate because it wanted to have a say in the Polish judiciary system. But from a democratic point of view, for me, it raises a question because once again the organization of the judiciary system in European member states is the competence of the member state. It's not a European competence. So it's a very, very tricky field once again, and I understand the reasoning of the court and for the previous judgment as well, but I think that this is debatable, at least, because there are different points of views. Yeah.
So I don't understand how either version of the rule of law really bears on Hitler. But I will say this. I mean, the biggest group that supported Hitler, one of the biggest groups were the lawyers in Germany, Carl Schmitt. The lawyer, well, they would have been the ones with the morally pregnant view of the rule of law. Also, if you're just talking procedure, I mean, Hitler won a plurality, but Hindenburg, who was basically decrepit at the time, had no obligation to appoint him chancellor. The problem was the Prussian military thought that they could control the man. It was an insanely wrong choice. But I don't think either view of the rule of law sort of would have helped keep Hitler out or stopped Lenin. You know, those examples, I don't really understand how they're meant to bear on this question. It's like if you have to mention Germany and Hitler and those sort of things, you've pretty much made a bad argument in my view. I don't even understand how that bears on this.
Okay. So on that note, and thinking about what happened to Adolf eventually, which was solved by war, not by debate, we'll end this panel, I think. So can we thank all our speakers for their splendid... Thank you all for staying around. We've got probably the most interesting part of the proceedings happening now, which is Bence in conversation with Janos Boka, the State Secretary for European Union Affairs, and we can examine or analyze further the often difficult relationship that has been evolving between member states who want their sovereignty and the power, overweening power of European Parliament and Commission laws, or injunctions, more like. So over to Bence.
Thank you very much, and thank you very much, State Secretary Dr. János Bóka, to being with us. That's a great pleasure, and this is a distinguished occasion. You know that today the conference was about the politicization of the rule of law. And I know that your background is not only State Secretary and representative of the government, but you are also an academic. And from this perspective, or from this both perspective of an academic and perspective of a state representative, could you please tell me whether you agree with this observation that there is a phenomenon of politicization of the rule of law?
Thank you very much for the invitation. It's a pleasure to be here. I'm really delighted to be invited, and I'm glad that you made reference to a previous phase in my life when, before becoming a state secretary, I actually had a decent job, and that was working for a university. And here I've been teaching EU law, but also comparative law. And of course, the idea of looking at how the concept of rule of law develops in the European Union and how it is used by institutions has always been fascinating. Maybe I will start a bit further, but I promise you, eventually I will get to the point. As a former university lecturer, it's always a danger to grab the mic because, in Hungarian universities, lectures last for 90 minutes, and university lecturers have a tendency of speaking for 90 minutes without interruption if you give them the microphone. But I will exercise self-constraint.
You will make us write an exam
at the end of the end of the intervention. There will be also an exam. But to get to the serious side, I would look the other way around. You spoke about the politicization of the concept of the rule of law. I will look at it from a different angle. And of course, as I understand, there will be time for a Q&A session at the end, and I would be happy to engage with you in an intellectual exercise and test whether the proposition that I make actually makes sense in an intellectual level. Politically, it makes sense, but intellectually, we'll say. So my idea is that we are not only looking at the politicization of the concept of the rule of law, because rule of law as a concept, in my understanding, is not really a legal concept. At least at the conception of rule of law, is not a legal concept. It's a very political concept that has to do with the organization and exercise of power. And in that sense, rule of law as a concept describes a very specific and modern way of organizing and exercising political power. So from this perspective, it's not a legal concept, it's a political concept. But this political concept has gone through a very interesting way of being judicialized, like everything that has to do with the exercise of power, whereby most of the discussions and most of the activities that previously belonged to the political terrain now belong to the judicial terrain. So my look at the development of rule of law is not rule of law becoming politicized, but an inherently political concept reaching a certain stage of judicialization where it starts to operate with the principles and the concepts that could also be interpreted in a legal way, and building institutions that are able to deal with rule of law related concepts in a legal way. Of course, there are also limits to how far we can push this, because these concepts are not legal per se, which means that it's very difficult to formulate rules that could be applied by judicial bodies in the traditional way judicial bodies apply rules. So principles related to rule of law have not become rules in the sense of traditional legal rules. They are more like principles, which means that they require different standards of application, interpretation, and so on, and different ways to assure their coherence. And I think that there are inherent limits to how far you can legalize rule of law as a political concept, and we can see the limits already in the procedures conducted by EU institutions. So this is the first point. The second point is that, okay, you can go to a certain level of legalizing rule of law related disputes and putting them in the legal sphere and entrusting legal institutions to deal with conflicts that are inherently political in nature and not legal in nature. But then, in the European Union, you see a different phenomenon whereby these issues that are domestically politically determined, so they take place in a domestic political context, and they take place in a domestic legal and institutional environment, are now transferred to a European level. And now you see that these debates and procedures that are now to an extent legalized or judicialized, now they take place in a European political context, and they are performed by European institutions. And in this context, you can actually speak about repoliticization of the rule of law related disputes. Originally, they were very political. To an extent, they have become judicialized or legalized, and now they are being repoliticized, but not on a domestic level, but in a European level. And I see this process developing both ways. The legalization of rule of law related issues continues, but now not in domestic political setting, but a European setting, not by domestic institutions, but by European institutions. And in the European political context, it is being repoliticized.
This afternoon we talked about, the competences of the European Union and the division of competences. And what do you think about this? Because issues are transferred to the European level that traditionally used to belong to the national level. So do you think is the right thing, or now going more into the politician?
Well, here I would tread very carefully, but I think there are a few specific points that I can also make in my capacity as a state secretary. Here, what strikes me is that we no longer have a meaningful debate on the division of competencies between the European Union and member states. My understanding of how the European Union works is a very lawyer can be interpreted from a very lawyer's perspective, where we have the treaties. These treaties contain specific rules and some principles as to the separation of powers and competencies between the EU and member states. I think that this system can be operated in this legal framework with a satisfactory degree of certainty. But this is not what we're doing. And there is no way you can meaningfully engage in an intellectual discussion with the European institutions on the separation of powers between the EU and member states. And how this operates in practice, you have to really understand what it means for the European integration to be and exist as an integration project. This is something that students learn at universities, that the European Union is an integration project. But I think that there are very few people who actually understand what it means for the European Union to be an integration project. Our understanding, at least my understanding of the European Union, is not the EU as an integration project, but the EU as a cooperation project, where member states and institutions cooperate in legal framework to achieve objectives that they cannot satisfactorily achieve alone, but they can better achieve it together. But this is not how integrationists see this project. For them, the measure of success of any EU project is not whether it delivers more, or it delivers more efficiently, or it delivers quicker as compared to individual member state solution, but whether it brings us closer to the ultimate objective of creating a federal entity in Europe. And if there is, let's say, a common enterprise, it might or might not be more effective than doing it alone, but it's not the ultimate measure of success. The measure of success, whether you can get one step closer to some kind of an integration or federalist entity on the European level. And I think that from this perspective, the fact that the European institution might or might not have competence to do what they are doing is irrelevant, because we don't really have this debate in Brussels or with the institution. The question is whether this brings us closer to a federalist Europe, and to this question, the answer is absolutely in the affirmative.
Yeah, and so in the following the goal of this integrationist project, there are several procedures that are ongoing against Hungary in the name of the rule of law. But what you mentioned, it's not only about the rule of law, or not mainly about the rule of law, but mainly about this big political division. Could you please brief us about what are the different procedures, because this is quite confused in the media, and if you can brief us about, update us where they are, at what stage they are, of course what you can say about the negotiations, but I know that you take part in them, so it would be real nice from you and an added value, of course, to today's conference.
There are a number of such procedures. Actually, there are quite a big number of such procedures, and if I want to go through all of them in some details, then I'm afraid you have to arrange not only for dinner but for breakfast as well. But I will. I will try.
That would be like in the European Council.
Yes,
no?
yes, indeed. At 4 in the morning, we get to a consensus no matter what. Okay, I will start with procedures that are rule of law procedures as such. So the idea and the nature of the procedures is directly connected to rule of law. And I think that there are two such procedures. One of them is the so-called Article 7 procedure that deals with the breach or risk of breaching values of the European Union. As you know, when it comes to Article 7 procedures, there are actually two Article 7 procedures. One is Article 7, paragraph 1, and one is Article 7, paragraph 2. Hungary is currently under the procedure according to Article 7, paragraph 1, that concerns the risk of breaches of certain EU values. This is directly related to rule of law as being one of the values on which the European Union is founded. There is another procedure that we call the rule of law review cycle that also specifically focuses on rule of law. This was started as an informal discussion among member states in the Council, but has now been dominated by annual reports of the European Commission on so-called rule of law reports that focus on certain issues the Commission considers to be central when it comes to rule of law. One is being judicial independence, the other one is being media freedom and media pluralism, the third one is corruption, and the fourth is civil society. These are the topics that are selected by the Commission for some reason to be central to rule of law, and then the Commission presents these rule of law reports. It is being discussed, and now as a new development for the second year in a row, the Commission also formulates recommendations to member states that they should follow in order to develop the rule of law situation. And this, the report is discussed in the Council annually, and there is the rule of law review cycle where in each and every General Affair Council session, every semester, there are 5 member states that are being looked at specifically as regards the rule of law situation, and then they are being asked constructive and less constructive questions by other member states, and they give constructive or less constructive answers to these questions. So these two procedures are specifically related to rule of law. Now there is one other procedure that is not specifically related to rule of law, but indirectly concerns rule of law, and is perceived by all outsiders as being a rule of law related procedure, and this is the so-called budgetary conditionality procedure, whereby if there are breaches of the principles of rule of law and they adversely affect the financial interests of the European Union, then specific measures could be adopted by the Council in order to protect the financial interests of the EU. Now, everybody calls this a rule of law conditionality procedure, but it is not a rule of law conditionality procedure, it's a budgetary conditionality procedure, because the objective of the procedure is not to correct rule of law deficiencies in member states, but to protect the financial interests of the EU. But everybody looks at this as a rule of law conditionality procedure because the political and the legal interpretation diverges to an extent. And of course, Hungary is the only member state under such procedures so far, so it's difficult to see whether it is actually something for the protection of the financial interests of the EU or it is a rule of law procedure. We will see. But this is a work in progress. And finally, there's a category where there are procedures that are not even indirectly related to rule of law, but are being used or abused for purposes related to rule of law. This is, for example, the European semester process, where you have country-specific recommendations, supposedly for economic policy coordination, but sometimes member states receive country-specific recommendations that have nothing to do with economic policy coordination. For example, Hungary received a country-specific recommendation to improve judicial independence. And these country-specific recommendations are now being used as a condition to access certain EU funds, for example, the Recovery and Resilience Funds. And now you have to take steps to implement country-specific recommendations for which you have to adopt the so-called Recovery and Resilience Plan, where you have milestones, for example, on enhancing judicial independence, and you have to implement those milestones in order to have access to certain EU funds. And last but not least, there are so-called horizontal enabling conditions that you have to fulfill in order to access certain EU budgetary funds, namely the cohesion funds. And one of the horizontal enabling conditions, for example, that Hungary needs to fulfill, also related to judicial independence. That has principally nothing to do with the efficient use of EU funds for certain purposes, but this is also used for issues that are somehow related to rule of law. This is a quick summary.
So this is a very good summary, and this is a very complex matrix. And my question would be, how do these procedures relate to each other? Is it possible to see it clearly? And when it comes to EU money, we all know that there is an ongoing negotiation, and this was a very dynamic negotiation with press conferences from both sides last year. And we thought that we are reaching an agreement. Then now we have the feeling that this agreement is becoming farther and farther away, because every time instead of getting closer, we hear from the Commission that there has not been enough progress. The European Parliament is putting pressure on the Commission. So what do you think, as member of the negotiation team, what do you think? Is it ever possible, and sorry to be provocative, but is it ever possible to reach an agreement with the Commission and to get the EU funds that are due to Hungary?
Of course.
So the official answer. Yeah, so thank you very much. So we are changing the topic now. I got the message from the government.
Of course, but I can elaborate on this, of course, a bit. The idea behind all these procedures initially was to make those procedures more effective. So the idea was that if we have more procedures that allow us to tackle the same issue from different perspectives, this would make the system as a whole more efficient, because these procedures would complement each other, would facilitate, would accelerate the process. I don't know whether in theory this actually holds. What I can say, in practice, it makes life and negotiations more complicated. I'm not saying impossible, and I'm not saying that there is no goodwill on behalf of the negotiating partners, because I don't doubt this. What I doubt, if everything is connected to everything, then you can only move everything at the same time, and I think moving everything at the same time in the same direction is more difficult than moving certain elements forward gradually. And the point that I want to make is that if the underlying political problem here is a deep mistrust between the negotiating parties, the only way you can overcome, you can breach this deep mistrust is making gradual progress in some areas faster, in other areas less quick, but constant gradual progress builds political trust that allows the resolution of the outstanding disputes if these are politically possible at some point. But if everything is connected to everything, you cannot really do this. Because you either solve everything, and until you solve everything, you get nothing, or you make gradual process that is not reciprocated, and then the already built political trust is basically burnt in the process. So the answer to the question is yes, of course it is possible. But the interconnected and intertwined nature of this procedure makes it extremely difficult to make gradual and constant progress that would allow us to build mutual political trust in the process.
I see that this is a time-consuming and energy-consuming procedure, but does the other part has the same feeling? I mean, that they are human beings on the side of the European Commission as well, and I think that then when they go home and they tell to the family what they did during the day, they may comply as well, that it is now that much complicated that maybe we should come back to one united procedure. I don't know what.
Well, first of all, I must admit that yes, there are human beings on both sides.
That's good. With the artificial intelligence here, that's a good sign.
And my feeling is that also my counterparts, they invest huge resources in this process, both human, material resources, time. So we are working 24/7. We are working night. We are working during the weekends. We are working through the summer. But my counterparts in the European Commission and other institutions, they do the same. So I cannot say that they are investing less human resource in this progress. And I think that looking at the issue from that perspective, I think it would be in everyone's interest if the process would be more flexible and would allow us more room for maneuver to solve the outlying political issues. That would be in everyone's interest.
Thank you very much. And you also mentioned that there is an evolution of the rule of law conversation, the rule of law dialogue in the Council. And I also mentioned in my presentation previously that 10 years ago, member states were much more skeptical to organize rule of law examination within the framework of the Council. And now what we see that it has become a kind of fashion, or it is, the Council really often deals with this question. So what do you think, what is the position, or why the position of the member states changed, or what is their position exactly on this rule of law debate? Are there still skeptical member states, and on the other side, rule of law debate promoting member states?
I think it again, it has not much to do with the usefulness or effectiveness of certain procedure. It's more a political or symbolic issue. There are quite a few member states for whom rule of law related procedures and the rule of law discussion in the Council is important politically as a symbol that they are engaged, they are devoted, and this is something that goes on also on the level of European institutions. And it has nothing to do with the fact that these procedures do reach their objectives, they are tangible results that we reach because of these procedures or not. That's a secondary. But I think that I can speak on behalf of a number of stakeholders saying that there are certain procedures that proved manifestly useless. And one of these procedures is the so-called Article 7 procedure that goes on for years now in the case of Poland and Hungary. We had, as regards Hungary, we had 6 hearings in the Council already, and we are not any closer to making this procedure worthwhile than we were after the first hearing. So I think that yes, there are some procedures that proved not useful or even counterproductive and divisive, and Article 7 procedure is one of those. Now the jury is still out on the so-called budgetary conditionality procedure. I know that it is also in the interest of some stakeholders to show that this process is useful, it works, and some stakeholders are already making certain proposals on how to make this more powerful, how to make this more broad, sweeping in scope. But I think that that it's very early to say the least whether this conditionality procedure actually works in the sense that it delivers for both parties and delivers for all stakeholders. And the same is true with the so-called RRP milestones and the system of governance that was introduced with the Recovery and Resilience Fund, where you have to reach milestones and benchmarks in order to have access to certain funds. It still remains to be seen whether this is the more efficient governance with EU resources, and whether to make everything contingent and dependent on compliance with certain policy objectives that are not necessarily related to the core objectives of the recovery fund. The jury is still out on that.
And just to specify, the recovery fund means that this is the fund which should be used to recover from the COVID-19 crisis, which is kind of over. So they took some time in Brussels, those guys. Don't they feel this? That this is a bit, in a moral basis, questionable that other countries got the money to have the recovery from the COVID. So during the negotiation, is there any, I don't know, human feeling about not helping out a country from this crisis?
Well, I will reply to this with a few numbers. The Recovery and Resilience Facility was designed as a quick intervention facility in the middle of the economic crisis triggered by the COVID-19 pandemic. Now, the EU has 27 member states. Out of these 27 member states, there are 6 member states who have not received any funding from the RRF yet. And there are 5 other member states who received only advance payment, which means that they have not received any payment based on the implementation of the RRP that were adopted. That's 11 member states out of 27. And this is an emergency response to an economic crisis that started in 2020. And now we are 2023. So you can judge for yourself whether this is the most efficient governance method or not.
Thank you very much. And next year we will have the Hungarian presidency of the European Council. We witnessed last week some nice attacks from the European Parliament on this matter. They questioned the credibility of the Hungarian government or the Hungarian state to tackle with the challenge of EU presidency. So what do you think about this issue, and what do you think how these rule of law debates can impact in general the Hungarian EU presidency?
Okay, first a few thoughts on the European Parliament's resolution that calls on the Council to do something so that Hungary do something so that Hungary cannot hold the rotating presidency. So legally and institutionally speaking, this is a non-issue, meaning that the question who holds the presidency of the Council is for the Council to decide. And the change in the rotation or adopting a decision that would put Hungary in a position so that we cannot perform our duties as a president of the Council is not on the table of the Council. So legally and institutionally speaking, this is a non-issue. We are preparing for the presidency. We have been doing so for a year now, and I think that the presidency preparations are, technically speaking, are not impacted by the European Parliament's decision. Of course, what is important for me to say that holding the presidency is not only, well, it's not only and not primarily a right, it's a duty, it's an obligation. So is the duty and obligation on behalf of all European institutions to cooperate with member states and other European institutions in the spirit of sincere cooperation. And I think that this also applies to the European Parliament. So the European Parliament is also under an obligation to sincerely cooperate with member states and with other EU institutions, including Council, also in the second half of 2024. And it is very far from me to to imagine that the European Parliament would put itself in a position not to sincerely cooperate with other member states and other European institutions. I think this is, for me, it's impossible to imagine from an institution that is the beacon of European democracy. As far as the political implications of rule of law related procedure on our presidency, I don't think that it will have any impact on the preparation and the organization of the presidency, since presidencies are supposed to be neutral and honest brokers in all procedures, and I think that it is in no way hampers our preparations. Political issues will always remain, and political stakeholders will always use this as a pretext to wage political attacks on Hungary and the Hungarian government. But for this, rule of law related procedures and presidency is only the pretext. It is not the cause and it is not the substance, it is the pretext. And if it were not for rule of law related procedures or presidency, there will be other pretexts. So I think that we should look at this political turbulence from that angle.
Thank you very much. And the final question before going to the Q&A, which is, I think, a relevant one. Poland and Hungary are under this rule of law criticism every time. Why these two countries? Or if you prefer, why Hungary and why not other 25 member states?
Okay, here this is a very complex question, and here I will only scratch the surface. But in Q&A session, I would be happy to engage further. The first part of the question is why us, and the second part of the question is why not others, or why not others as well. These are two different questions, but interlinked. Here I must return to the very first point I made, that rule of law is a political concept that has been legalized or judicialized and now is being repoliticized on a European level. And I think that the reasons for Hungary and Poland being singled out can be found in this repoliticization of the process. And here I think that there's a fundamental underlying political conflict between certain European institutions and stakeholders and these two member states that can only be interpreted in a European context, which means that the solution of this conflict lies also in this European political context and not in the rule of law situation itself. And the question is, why not others? Here, the answer is more or less the same. I think that as long as the underlying political conflict between member states and European institutions does not exist, then these processes will not be triggered, or these processes will not reach such prominence as in the case of Hungary and Poland.
Thank you very much. And now, question to the audience. I think that Rodrigo tried to ask the question during the whole afternoon, so now it's your time.
Yeah, thank you, because you have been criticizing a lot the whole afternoon the European Parliament and the Commission, but I also wanted to criticize a bit the Council of Ministers, so basically your peers, the other member states. For example, a decision whereby Hungarian students as from September are going to be kicked out from Erasmus, and this is about to happen, and this is the most disgraceful thing that the EU ever did, in my opinion. It's not a decision of the Commission, it's a decision of the member states. And so, two questions related to that. First, I thought that a little more conservative friendship among the ministers would have helped. I thought that an Italian government or a Swedish government would have helped, to avoid decisions like this one. I don't have the impression that this is the case. If you can tell us a bit more about it, and also about Erasmus in general. I mean, how come? I mean, do they realize the extent of the decision they are taking? A more legal question as well. Do you think that the fact that the European Commission has the monopoly of the initiative to launch an infringement, and can do it or not do it without giving any explanations, and this is also in the court of in the case law of the Court of Justice, do you think that this is also a fast track towards arbitrariness? Do you think that this helps? Don't you think that it's basically a way to infringe the rule of law in the name of the rule of law?
Thank you very much. Very, very, very pertinent questions. I I will try to address them as much as I can. First, as far as the access to Erasmus program by Hungarian university students is concerned, I think it's a complete mess, both politically and legally speaking. It's very difficult to explain not only to Hungarian students but even to lawyers how it contributes to the protection of the EU's financial interests to disallow access for Hungarian university students to the Erasmus program, where it is difficult even to imagine how to abuse Erasmus funds at all. And if it would be theoretically possible to abuse Erasmus funds, how Erasmus students themselves could abuse Erasmus funds. So it's very difficult to see what financial interests the European Union is protecting by excluding Hungarian students from the Erasmus program. On the other side of the story is that, of course, Hungarian Erasmus students cannot participate in the program, Erasmus students of certain Hungarian universities, but other European students participating in the Erasmus program, they can visit those very same universities whose students are excluded from the program, and because they are not excluded. So this points to a discriminative practice, I can say, which is against the very basics of rule of law, I think. What I can say that from the very beginning it was not clear why this specific measure is included in the list of measures that was adopted by the Council. But this is a path-driven process where the Council sometimes is not in the position to examine Commission proposals in such detail as it should be required in order to make a well-funded decision. This is how the institutional structure works, and this is how it has been working for decades now. And I think that the Council, since it is now in the position to deliver decisions that impact on the daily life of many individuals, also in the budgetary conditionality procedure, I think the Council should grow up to the responsibility and the task and do not only independent legal analysis, but also do an independent political analysis of the Commission proposal that it is adopting. I think it is very important. So this is the first part, and whether these rule of law related procedures are infringement of rule of law itself, I will not answer this question directly. What I will say that those principles on which the European Union is founded in Article 2, Treaty of the European Union, these principles are first and foremost applicable, or should be applicable, to the European institutions themselves. And European institutions have been busy developing ways and means to check the implementation of these principles in member states, but they were less enthusiastic when it comes to designing procedures to check these principles being properly applied in European institutions themselves. And I think that this is one way to turn this rule of law pyramid upside down, to say whether these principles are respected by the European institutions themselves. Because if we read carefully what's in the treaties, especially in Article 2, this is something that should apply to the institutions. It is the institutions that should apply these principles that were originating and developed in the member states. The political meaning of Article 2 is that all those principles that were developed in member states, these principles should be applicable to the workings of the European institutions themselves. This is what Article 2 is all about. It's not about member states, and definitely not about European institutions checking how member states comply with these criteria. But unfortunately, we are way past this phase of the debate in the European institution. Nobody really has a meaningful discussion on the origin and actual meaning of Article 2.
Thank you very much. Other questions from the audience? Professor? No?
A short question. The application of the rule of law cannot be defeated. What's your opinion? Discovered flexible weapons of or for politics and easy hard power. For example, I will twist and turn until I am always right. What's your opinion?
I'm not sure I totally understood the question in its full depth, but I think that it relates to the very nature of rule of law being a political concept that has reached a certain level of being legalized. The rule of law will, I think, for the foreseeable future, will not lose its original nature as being a principle, and as such, it requires very special ways of interpretation, application, and implementation, and will never be as straightforward as a traditional legal rule. And I think that that's why applying rule of law is, or principles of rule of law, is an inherently political process that might be done by institutions that are not inherently political in nature and that use interpretation methods that are not inherently political, but the reason why they have political and democratic legitimacy is because these institutions are embedded in a domestic political context. And the fact that now some of these functions are performed by institutions that are not embedded in domestic political context, but a European one, and where democratic legitimacy of these institutions is not so straightforward as for national institutions, this brings up the issues of legitimacy of these procedures. And I think that the expression that you use, that you can twist and turn principles this way and that way around, relates to the very political nature of settling these issues related to rule of law. And that's why I think that these institutions and these procedures somehow will have to be anchored in domestic political processes in order to gain legitimacy.
Thank you. Do we have other questions? John?
I think obviously this question stems from the last question and other questions. Isn't there an obvious gap, fissure, a canyon between, on the one hand, the existence of the ECJ as a court which is under instruction from the treaties to take into account moving towards further integration, on the one hand, and secondly, political system in the EU itself and in all of the countries in which there are political parties and I think a recognition by the system that it is legitimate to argue going in the opposite direction, especially in relation to subsidiarity. How do you think that particular fissure is going to be closed in a democratic way? And secondly, following on from that, obviously quite a lot of the discussion here has got in the background the idea of European values. But it looks, how do these values come about? And secondly, how can we try to ensure that they're not simply the values of a European bureaucracy or political class rather than that of Europeans?
On the European Court of Justice, I must tread very carefully because I have enormous respect for the institution. And that being said, I think it is clear that the European Court of Justice has an image of itself as not the neutral arbiter of developments in the European Union, but as a player in the process whose objective is to further European integration as such, especially in circumstances where the political impetus towards integration is waning or less obvious. And this is what the European Court of Justice has done in the 70s, for example. It is what the European Court of Justice has done in recent decades, where in certain areas of integration, the political will towards integration was waning. And here the European Court of Justice saw a role for itself to further the integration process as such, which puts the Court of Justice in a very special position And I think that a certain tendency towards interpretation of provisions of primary and secondary law is basically wired in this institutional setup, and it is a natural consequence of the self-immediate perception of the court. And this, of course, disqualifies certain legal arguments or certain line of reasoning from litigation before the court. And it also disqualifies certain principles, such as subsidiarity, from being meaningfully applied in the process. And I think that this goes a long way in basically analyzing and understanding the development of the jurisprudence in the court in certain areas. I think this is as far as I can go in answering the question. As far as the values are concerned, so what is the source of the values that the European institutions uphold? This is the million dollar question. I would like to make only 2 points. One is that the European Court of Justice itself has been very inventive in this area. The European Court of Justice, even before any specific reference to fundamental rights, for example, was able to develop a whole branch of jurisprudence on the protection of fundamental rights by the European Union as such, without a single treaty reference to this. Like mathematicians or writers, literary figures, the European Court of Justice managed to create a whole universe out of nothing. This has been done before any reference to such was included in the treaties. And here the Court of Justice was very creative of identifying, of course selectively, sources of fundamental rights, specific fundamental rights that is protected by the European institution, specific interpretation of those fundamental rights. This also applies, we can see this now when it comes to values. The new buzzword is now that the European Union is not only a community of law, but a community of values, which means that values take precedence over law, but then you have to develop the same ways of finding these values, interpreting these values, and I think that the European Court of Justice manages quite well in this, being very inventive in this area.
Thank you very much, State Secretary. And we are ending the conference now because we are over time. Thank you very much for being with us once again, and we know that your agenda is very, very tough, a lot of obligations, so thank you for sharing your thoughts. And thank you for the audience. So thank you for the audience for being with us during all the afternoon and evening and showing that this is a matter of interest. Rule of law is not only for lawyers, this is for every citizen who is interested in our everyday political life. Thank you very much.
Could I just repeat the thanks you've given to the speakers? Thank you very much, State Secretary. That was a very thorough and very interesting elaboration of the arguments. Secondly, I'd like to thank all the other speakers. It's been a very good afternoon. I mean, let's face it, a large audience has stayed throughout. They could have crept away, but they didn't. So we're grateful to them for doing that and treating this as the serious topic it is. But there's another person. Benza, this is your brainchild, and you conceived it and carried it to fruition. I'm very grateful. Our thanks are to you as well.